She goes there. Yeah, I don't care.
Yeah, it's the Latin Nation.
Yeah.
Her brother in the hospital. So,
Maybe Taylor and I are gonna try to get together, you know.
whatever, man. That's what I've been telling.
I'm like, I ain't stressing about that.
Yeah.
It's gonna be a big deal. Gets me out half to go to, Cambridge County tomorrow.
Yeah, there you go.
I want that down there tomorrow. I might go.
Yeah.
Tell them that off. So I have to drive.
There you go. Yeah, I tried to tell her, but
I know, Sarah did too.
Yeah.
They would deal with me all the time down there, like, I don't even care, it's whatever, just one of them.
yeah.
You know, we do what we can, right?
Well, at first, I think we watched it, so we're doing, at first it was shooting off the year available at all.
Oh, that was a
Yeah.
problem, yeah.
And so then.
Not about to get.
Yeah. But listen, we want to have a court reported like late
Yeah.
April. So that was what was stressing her out. And then we finally got a hold of her and she's like, I'll be there Wednesday. So that's.
Something put on this minute, those also, yeah, it's the officer. Yes, I don't know, they're changing, that's the officer, whatever the ones are for today, and then we have to write it like 3 or whatever. But just think of it.
Yeah.
Some shit to do. We don't have plenty to do.
Right.
It's not like we're gonna be doing nothing.
Yeah. That's all.
Okay. Okay, Newbert.
Why would I get to give you
Newbert.
Thursday?
Come here, baby.
Yeah, we should actually,
So,
Yeah.
we should be able to. do it Wednesday.
Yeah, we just put on the lab check, or whatever, my Thursday, on Wednesday, 1:30. I don't mean, 30 minutes maybe. Nah,
Make sure you come back. Yes, ma'am.
Damn, that was very quiet.
Yeah, that's what I told her, that you're not difficult on the lack.
Yeah.
There's some extra ways.
All rise. County Court Order to now is session or for Judge Terrence on presiding.
You may be seated. Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You've been asked to come to court today for a criminal case. This is the proceeding that we're in is called an arraignment. And what the arraignment is, it's an opportunity to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court, as I mentioned to you earlier, is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your serious type of offense, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if the person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder. The range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, you have a misdemeanor case, so you don't have to worry about those type of punishments. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors for cases that normally start in the JP court or the city court. For example, speeding ticket, not having your seatbelt on, and having expired inspection sticker, those are Class C misdemeanors. Now, with the Class C misdemeanor, the range of punishment is a fine only. You cannot be given jail time. It's a fine only. And the fine cannot exceed $500. Now, the way the case comes to this court is when the person appealed their case, they get convicted in the JP court or the city court, and then they file an appeal. Then it comes to this court, and then you get a whole new trial. Now, if they're convicted in this court, the punishment range is the same, it does not change, which means that they could be given a fine up to $500. Now, however, if they fail to pay the fine, or if their fine was converted to community service and it failed to perform the community service, then the court can issue what is called a Capers Pro fine. That simply means that it's a warrant for your arrest for you to either pay the fine, or if not, you can serve the fine out in jail and you get credit at $100 per day. Now, the next highest misdemeanor is Class C misdemeanor. Now, the next highest misdemeanor is the Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to maximum 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both jail time and a fine. And the highest misdemeanor is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such jail time and fine. Now, you may be eligible for probation, and if you get probation, you don't go to jail. You serve your time in the community. And so, if you get probation, there are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And with that type of probation, we usually call it deferred probation. You don't have a conviction on your record. And if you successfully complete the probation, you won't have a conviction on your record. Now, if you successfully complete the probation, you don't have a conviction on your record, you may qualify for what we call a non-disclosure. A non-disclosure means your record is sealed, okay, to the general public. That means the general public can't go into that case and open it. Now, notice I say general public. That's because the government or governmental agencies that are listed in the Code of Criminal Procedure can have access, but the most of the public is the general public, so they cannot have access to that case. Now, the next type of probation is called adjudicated probation. So the first one was unadjudicated probation. The next type of probation is called adjudicated probation. Now, with adjudicated probation, you do have a conviction on your record. However, if you successfully complete the probation, there's something that is called judicial clemency. But a judge or the court can set the conviction aside and you will no longer have a conviction. Now, in order to qualify, 3 things has to happen. First, it has to be, you have to successfully complete probation, cannot be any more time left on the probation, and you have to be given a discharge by the probation department. If those 3 things happen, court has the discretion to set the conviction aside, and you will no longer have that as a conviction. However, if you get another conviction later on, then this case that you got judicial clemency on can be resurrected, brought back up, revived, and used against you. And if you try to get a license with CPS, Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. All right, now, the paperwork that you have, I'm going to go over that paperwork with you on the clipboard. The first document that you should see is titled Judge's Explanation of Rights to Defendants Without Attorney. Everyone should be looking at that document, because everyone will have to sign that document, make a choice and sign it. Now, the document states that as the defendant in a criminal case, you have three options regarding your right to have an attorney. And it states that number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, the first paragraph states that if you want an attorney, and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. Second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is on the clipboard that is titled Affidavit of Indigence. Okay, it's a 3-page document. You will have to fill out the first page, and then on the second page, at the top, it says defendant's oath. You would have to read and sign that box. And then in the middle of the document, it says unsworn declaration by defendant. You would have to fill out that portion, and then you'll stop. That's only for individuals who will be requesting a court-appointed attorney. If you're not requesting a court-appointed attorney, you don't have to fill out that document. All right. Now, the next paragraph on the judge's explanation, the third paragraph, it states that you may not talk to the prosecutors. The prosecutors, we have 2 of them in court today. They are assistant criminal district attorneys that work for the Jefferson County District Attorney's Office. We call them prosecutors, or you can call them assistant criminal district attorneys. And the reason why they say you can't talk to them is because of this. They say you can't talk to them unless you first sign a waiver of your right to have an attorney. Now, if you would like to represent yourself, that is, give up your right or waive your right to have an attorney, you would like to represent yourself, at that point, you'll be acting as your own attorney, and you'll have an opportunity to talk to one of the prosecutors to see if you can work out a settlement or a plea bargain on your case. But before you are able to do that, you have to first sign a waiver of counsel. The waiver of counsel is another document on that clipboard. That's for individuals who will be waiving their right to an attorney. That document is on the clipboard and it's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You'd have to read and sign that document and date it. The date is March 18th. Now, for those of you who would like to waive your right to have an attorney, you should be aware that the last paragraph says the advantages and disadvantages of self-representation. Waiving your right to an attorney representing yourself may result in the worst outcome for you in your case, including a loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive, or if you choose to represent yourself, that is, waive your right to have an attorney represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Okay? So at some point, let's say you decided that you were going to waive your right to have an attorney, you talk to the prosecutors, and then at some point you say, well, I want an attorney. You can change your mind. All right. Now, at the bottom of that document, in bold letters, it states defendant's choice. Mark the initials next to only one choice. If your choice is to hire your own attorney, now the document I'm talking about is the judge's explanation, that first document. At the bottom of that first document, it says, in bold letters, defendant's choice. mark your initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. Okay? You place your initials on the first line at the bottom to the left. All right? Now, if you have already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to represent yourself, that is, waive your right to an attorney, represent yourself, then you'll place your initials on the fifth line, which is the last line, to the left. And now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that's titled defendant, and you will date it today's date, March 18th of 2025. Now, just as a brief recap, everyone is going to sign this document. Okay. If you want to hire an attorney, this is the only document you will sign. You will place your initials on the first line, sign it and date it, and that's it. If you would like to apply for a court-appointed attorney, you will you'll place your initials on the third line of this document, sign it and date it, and then you will fill out the document that is titled Affidavit of Indigence, the first page. And on the second page, where it says defendant oath at the top, you will sign this, date it, and then where it says unsworn declaration by defendant, you'll sign this middle portion and then you'll stop. That's all you have to do. If you would like to represent yourself, that is, waive your right to have an attorney and represent yourself. On the judge's explanation, you'll place your initials on the fifth line, sign and date it, and then the document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial, you would fill out this, sign and date it. So you're gonna fall in one of the 3 categories. If you represent yourself, this is the only document you sign. If you sign for court-appointed attorney, you sign this document and the affidavit. If you're doing a waiver, place your initials on the fifth line on the explanation, and then you sign the waiver, sign and date the waiver, and that's it. Okay? So you're gonna fall in one of the 3 of those categories. Anybody have any questions? Yes.
So, was this straight oath, we're doing, apply for court appointed?
You okay? You just saying that you're applying for a court-appointed attorney. You're gonna fill out the first page of the affidavit. Okay, the whole first page. And then on the second page, only thing you're gonna do is go to the top of this form and fill out where it says defendant oath. And then where it says, once you finish that, you go to unsworn declaration by defendant and fill out that, and you stop. You don't have to do anything else. Everything else is for the court.
Unsworn, so,
Huh?
unsworn and fine, so that's it.
Yeah, once you say unsworn, then you fill out that unsworn declaration, and that's it. Where it says defendant currently meets it, that's for the person that making the decision as to whether or not you meet the eligibility requirements for the appointment of a court-appointed attorney. You don't have to worry about page 3 then. Okay? Anybody else have any questions? Okay. Now, before you start filling out that form, I need to inform you that you have some other rights. One of the other rights that you have is a right to have a trial by jury. That area over there looks like a box. We call it the jury box. And 6 citizens from Jefferson County will be selected to serve as jurors in your case. Now, they will listen to the evidence, listen to the arguments. They will go into the jury room and deliberate. And then upon the completion of the deliberation, they will decide whether to find you not guilty or guilty of your choice. You also have a right to waive or give up your right to have a trial by jury. Now, if you waive or give up your right to have a trial by jury, your case will come before the court in one of three ways. One way it can come before the court is by way of a trial. Somebody might say, well, how can you come by way of a trial if I waive my right to a jury? Well, you will be having what is called a bench trial. That's a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to the evidence, listen to the arguments. The judge will apply the facts to the law and decide whether or not to find you not guilty or guilty. And the next way, if you don't want a trial by jury or by judge, then you're telling the court that you would like to enter a plea of either guilty or no contest. If you enter a plea of guilty, you're telling the court that you committed the offense you've been charged with. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges. Now, if you enter a plea of guilty, no contest, and you would like to enter a plea, you'll have an opportunity to talk to the prosecutor. Okay. Or if you represent by the attorney will have an opportunity to talk to the prosecutor. And if you are able to work out a plea bargaining agreement or a settlement in the case, we call that a plea bargaining agreement. Okay? Now, once you have a plea bargaining agreement, you will bring that agreement before the court or before the judge. The judge can do one of two things. The judge could accept or reject your agreement. Now, if the judge rejects your plea bargaining agreement, let's say you're in the state of worked out a plea bargaining agreement and the agreement is for you to get deferred probation. And it comes before the judge and the judge says, well, I'm not going to follow that agreement. Then you could tell the judge, well, since you're not following my agreement that I made with the state, I take my plea back. I'm not pleading guilty and I'm not pleading no contest to this charge. You can do that. You can withdraw or take back your plea. Now, if the judge does follow the plea bargaining agreement, and so let's say within 30 days, you decide to appeal your case because you have a right to appeal your case. Let's say within 30 days, you decide to appeal your case, you have to get permission from the judge to appeal your case if you follow the plea bargaining agreement. If he gives you permission, then your case is going to leave this court and go right upstairs to the Ninth Court of Appeals. There are 4 appellate judges up there. They will review the case. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court with orders. One could be an order to give you a new trial. Now, if they deny your appeal, then you can appeal it to the highest court, the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, which is located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review, and I'll explain that to you. Pro se means you're representing yourself. You don't have a lawyer. You file this petition on your own. You're representing yourself, and you're petitioning the Texas Court of Criminal Appeals to review your case, to see whether or not your appeal should have been granted upstairs, or whether or not you've been wrongfully convicted in this court, or this court committed an error by convicting you. They can do one of two things. They can either grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. All right? Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Okay, it could be an order to give you a new trial. Now, if they deny your appeal or your pro se petition, then at that point your conviction will stand. Okay. Now, You also have a right not only to have a trial by jury, a right to waive a trial by jury, a right to have a bench trial, waive your right to have a bench trial, right to have an agreed plea bargain. You also have a right to have what is called an unagreed plea bargain. What that means is this. You in a state, or you and your lawyer, talk to the state, try to work out a plea bargain agreement. You didn't like, what they was offering. Okay? So you want the court to give you punishment. You want the court to decide what your punishment is gonna be. Let's say the state say, okay, the offer is, 200 days in jail. I'm just making that up, all right? And you say, well, I don't want no 200 days in jail. Well, I want the judge to decide what my punishment is gonna be. And then the judge could decide anywhere from fine, jail time, or probation. The jail time is fine. So the full range of punishment is before the judge to decide what your punishment is gonna be. So that's called an unagreed plea bargain. When you don't like, you can't agree with them, you want the judge to decide. All right. Now, the other right that you have is the right to have witnesses to come to court. That chair that has the microphone in front of it, we call it the witness stand. What witnesses do? They can testify. They can testify for you or against you. You can ask some questions if you represent yourself. Or if you have a lawyer representing, your lawyer can ask some questions. We call it either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses. What that means is you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses. Now, you also have a right, we call it a Fifth Amendment right against self-incrimination. Fifth Amendment is from the Fifth Amendment of the United States Constitution. You have a right not to testify, okay? In essence, Fifth Amendment right against self-incrimination, you have a right not to incriminate yourself, not to testify. They can't force you to testify. The state, the government, the DA's office can't call you to the witness stand. You know, they can't say, I call the defendant. No. If you exercise your Fifth Amendment right, you have a right to remain silent. And I know a lot of times we watch television and we see on these television shows like Law and Order, somebody might be on the witness stand, or they might be in the public, and if they're in the public, the police officer go up and talk to them and say, well, I need to talk to you. So I take the fifth. Right? Or if they're on the witness stand, I take the fifth. Lawyer is trying to ask a question. You have a right. It's called a Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. If you waive or give it up, that means you will be testifying in your case. All right. Now, the other right that you have is called a right to have discovery. Discovery. That simply means you have a right to see what's in the state's file. You have a right to see the evidence that they're going to be using against you. You have a right to discover or see the evidence that they will be using against you. You have a right to see witness statements, your statements, police reports, lab reports, photos, audio recordings, listen to audio recordings, see video recordings. You have a right to see documents or have access to instruments. Whatever they're using, whatever they have, you have a right to have access to that. That's called discovery. Now, you can waive or give up your right to have discovery, which means that you would not be having access to the evidence that they have and that they will be using against you. Okay. Now, everyone that's here for arraignment, you've been arrested, placed in jail, you've been charged, well, you've been let out of jail on bond, okay? And you get out on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you pay a bond with a percentage of the bond, or you're out of jail on what we call a PR bond or personal recognizance bond. That simply means that you were released without paying anything. You was released under your own personal recognizance with a promise to appear here in court. Now, I said that to say this. Every day that you have spent in jail can be used as credit towards your punishment. Now, the operative word is every day. And the reason why I say that is because let's say you were arrested you was booked into jail at 11:59 PM on last night. And then you got out of jail 2 minutes later at 12:01 AM this morning. That's 2 days. That's 2 minutes. I mean, okay. But it's 2 days. It's 2 different days. Okay, so you get credit for the 2 different days that you spent in jail. Okay. Now, if you spent 5 days in jail, the state is offering through a plea bargain agreement that you serve 5 days in jail, that means you won't have to serve any time. Why? Because you will be given credit for the 5 days that you have already served. We call that credit for time served. Now, if the state is offering fine and court costs, in this case, now, you should be mindful that every day that you spent in jail, you are credited at $100 per day. So if you spend 5 days in jail, that's $500. That can be used toward your fine and court costs. So if the state is offering you fine and court costs of $500, you spend 5 days in jail, you don't have to pay anything. Why? Because you have enough time to pay it off. The time in jail has already paid it off. Therefore, the fine and court costs will be what we call taxed and retired. You don't have to pay it. Now, if you spent 5 days in jail and they offer 7, that means you have to do 2 days because you subtract 5 from 7. Now, if they're offering that you pay a fine of $700, you spent 5 days in jail, which is $500. That means you have to pay $200 because you subtract 500 from the 700, that leaves 200. Now, you'll be required to pay the fine on the day that you dispose of your case or take care of your case. Now, if you cannot pay the fine on the day that you take care of your case, no problem, because we can put you on a payment plan. You could pay off so much a month until it's paid off. Now, if you're unable to pay a payment plan because you may not have the income, no problem. Because we can convert the fine and court costs to community service. And for every 1 hour community service that you perform in a nonprofit organization, $12.50 will go toward the payment of your fine and court costs. So for example, in the scenario that I gave, you owe $200. If you work 8 hours one day, that's $100. You work 8 hours another day, that's $200. You work 2 8-hour days, that's $200. Okay. Now, Jefferson County has a program for first-time offenders. If you haven't been in trouble before, first time here, first time getting in trouble, they have a program where they will dismiss your case. And not only will they dismiss the case, but you can get it wiped off your record. Okay, or then we call it expunged from your record. Erased, deleted, or wiped off from your record. And the way it works, in order for you to qualify, 3 things has to happen. 1, it has to be first time getting in trouble. That's 1. 2, it can be an offense for evading arrest, resisting arrest or unlawfully carrying a weapon. And 3, you have to have an attorney to help you with the application process. And if you get in, as I mentioned to you earlier, they dismiss the case, you complete the program, then you can get it expunged, erased, deleted, or wiped off from your record. Okay. Jefferson County, when I say Jefferson, I'm talking about the district attorney's office. They have another program for veterans. If you're a veteran of any one of the branches of the United States military, they have a program called Veterans Court. And with the Veterans Court, only thing you have to do is be a member of any one of the branches, a veteran of any one of the branches of the United States military. What they will do, once you get in the program and complete the program, they will dismiss the case. And then, upon the dismissal of the case, you can get a non-disclosure where your record is sealed to the general public. Okay? This court, County Court at Law Number 2, has a program that God led me to start in the first 100 days of taking office. The program is called the Community Safety Initiative, normally referred to as the CSI program. And with that program, the program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so in order to stop people from being in that cycle of committing crimes, we have the Community Safety Initiative. Now, I use the term cycle is because there's a cycle where individuals it starts with an individual don't have an education, can't get a job. They can't get a job, they turn to drugs and alcohol. They get depressed, they turn to drugs and alcohol. Once they turn to drugs and alcohol, they eventually commit a crime. They commit a crime, they eventually get caught and do time. And once they do time, they get out. And then they're right back in the same cycle. In order to break the cycle, we have the Community Safety Initiative. Now, with the Community Safety Initiative, we have partnerships with local agencies. And one of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local mental health center here in Southeast Texas. And with Spindletop, they have the expertise to address your mental health issues or mental health issues. For example, you do not have to be incompetent or insane to participate in the program. You could merely suffer from depression or anxiety or any other host of mental illnesses. And Spindletop has the expertise to address mental health needs. Now, what they will do from the beginning, they will conduct a private interview. We have a jury room in the back. It could be a private interview in the jury room or at their facility or by telephone, whichever is convenient for you. Then they can do an assessment to determine what the mental health issue may be. And then they can develop a treatment plan, either for outpatient or inpatient treatment. Spindletop also has another program that is called ATAR. It's an acronym, ATAR, that stands for Addiction Treatment and Recovery. We have a partnership with our local Drug and Alcohol Council that has a program that is called Ozone. It is also a drug and alcohol treatment program. OSAR, OSAR, stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do, they will conduct a screening, they will do an assessment, and they develop a treatment plan for either outpatient or inpatient. And the reason why we have partnerships, not only with Spindletop, as well as our local drug and alcohol council, because it's not uncommon for individuals to have what we call alcohol problems and mental health issues, or drug problems and mental health issues. It's called what we call a co-occurring disorder. So that's not uncommon. Now, if you are unemployed or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center that has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. So, a lot of times people might have training and they go apply on their own with maybe one of the plants or one of the local businesses. They don't get the job. But with CICE, they go in on your behalf. You get the job, okay? So that's one of the beauties of being in that program. Now, if you have not graduated from high school or you do not have a GED, graduate equivalency diploma, well, CICE also has a GED program where you can get your graduate equivalency diploma. Now, All of those programs that I just talked about are free. Doesn't cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And if we address the problem, we can produce productive people. And if we produce productive people will not commit crime. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community. Why? Because what comes out of the home goes in the community. And so if you're interested in any one of these programs, just simply let us know. And we'll be happy to point you in the right direction. We have brochures. We can get you in the right direction so that we can address whatever need that you have to make you more productive. Okay, now, at this time, we have two individuals. We have Caitlin, we have Deputy Henry. They're from Spindletop. They're going to come right now and tell you a little bit more about what Spindletop has to offer. Deputy Henry, Caitlin.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state, commissioned here with the sheriff's department. This is Caitlin. Now, Caitlin is a qualified mental health professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person that comes before the bench. See, what the judge has found with statistics proof is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just lack of community resources to help you with your particular situations. Now, maybe this is your first time to be in court, but your fifth time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life. If you're gonna need something from you, we're gonna need you to share that need with us so we can see best how to advocate and help you. And Caitlin's gonna explain exactly how you can do that very privately.
And the paper that I pass out to everybody when they walk in, at the top is basic information, and it's name, birthday, phone number, email. We use those things to put you into our system. And then under that is how would you like to be contacted, and the options are call, text, and email. Whatever you check is how I will contact you. I will not contact you unless it's checked on these box. And underneath that is what I need help with. And most of the resources is me emailing you a link of things that you will have to do yourself. But if you were to check mental health, which is PTSD, depression, or anxiety. Yes, there you go. Or if you were to check substance use, that would be any drugs or alcohol. And if you were to check mental health or substance use, then you would work hand in hand with Spindletop to get you the resources and the services that you need. Everything under that is self-explanatory. Yeah. Everything under that is self-explanatory. If you want to talk to me in person today, then write anywhere on your paper, please talk to me today. And once the judge calls you up and he's done with you, I'll come and get you. We'll pull you into a back room where we can talk privately. Or if you want me to call you anytime today, then just check the call box and put please contact me today. If you don't care if I contact you today, if you want me to contact you sometime throughout the week, then you can put that on your paper as well.
So why does this matter? There's a lot of resources out there that don't spend money on marketing. They spend money on the resources itself, so they're not well known. But we do have access to that, and we can get you connected to that. The first resource I can actually provide you today is this business size card. It has a 1-800 number on there. If you ever find yourself in an unsafe place, you can call that number and get help immediately. And I'll get this out there to everyone just shortly. Again, just shortly, the court is going to go into recess. When it does, we'll be able to come out there and we'll visit with you. We'll pick up those documents from you. I'll be handing this out to everyone who wants one. And we'll be able to answer any questions you have. Thank you, Your Honor.
Okay, thank you, Deputy Hinton and Kate. Okay, ladies and gentlemen, we're going to go into recess in a few minutes. But before we go into recess, I need to give you some additional information. Now, you're gonna have time to fill out the paperwork. If you need help with filling out the paperwork, we have our core personnel who's here, including me, who will be happy to assist you with filling out the paperwork. Now, we will pick up the paperwork from you. Okay, and then we're going to go through the paperwork, and that's gonna take some time. Now, if you need to use the restroom, there are two restrooms right out in the hallway. The men's restroom is right in front of the county court at law number 3, which is right next door. And the women's restroom is on the opposite side of the hallway in front of the 172nd District Court. Now, you're allowed to go out in the hallway and use the restroom. Please do not leave the courthouse. If you leave the courthouse and you call your case and not here, your bond could be forfeited. And if your bond is forfeited, that simply means that a warrant is gonna be issued for your arrest. And we're gonna have to go through this process all over again, after you go to jail and book out and come back here, okay? So to avoid that, please do not leave the courthouse. And again, this is only gonna take us a few minutes. And the other thing I'd like to mention is, we're still in court. And so make sure that you conduct yourself accordingly. All right? So at this time, we're going to go into recess, and then we're gonna have, folks from Spindletop, our court personnel is gonna come out to assist anyone that, needs some assistance. And then if you finish your paperwork, we're gonna ask who's finished, you're gonna raise your hand, we're gonna turn the paperwork into the bailiff, and then we're gonna try to get you out here as soon as possible. All right? Court is in recess.
Make sure you go to the restroom or outside or whatever, make sure you make your paperwork.
Session with the arraignment docket on today's date, March 18 of 2025. First case is cause number 25 CCCR 0180. Case is style the state of Texas versus Bragnes Acacia Godfrey. Ms. Godfrey, would you please come forward? You stand right there. Ms. Godfrey, before we get started, you have a right to have a record made of the case by a court reporter. You also have a right to waive or give up your right to have a record. Do you waive or give up your right to have a record? A record is where they type down everything that's being said. You could have somebody to type down everything that's being said, or you can waive or give up your right. Waive it? Okay. Okay, now, Ms. Godfrey, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Godfrey, you may put your hand down. How are you doing, Ms. Godfrey? I'm doing fine, thanks for asking. Ms. Godfrey, the state is represented in this case by Attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
That's good. Now, Ms. Godfrey, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Bragnes Acacia Godfrey, on or about December 21st of 2024, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of theft, Mr. Godfrey. Do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead guilty?
No
Not guilty, no contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Okay, now, Ms. Godfrey, I also have before me on my computer a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Ms. Godfrey, there are 2 sets of initials.
Mm-hmm.
The first set of initials is below a paragraph that is titled waiver. Did you place your initials on this line next to the box that's checked no contendere, which means no contest? The second set of initials is below a paragraph that is titled Discovery Admonishment. And it is next to a statement that reads, I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document? Yes. On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature? On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Okay. Now, also, I have before me 2 documents on paper. The first document on paper is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state that you would like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Everything is mine, sir.
And is this your signature on the line that's titled defendant? Okay. Now, Ms. Godfrey, before you sign and initialed all of these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay. Ms. Godfrey, are you a citizen citizen of the United States.
The state offers states exhibit
Okay.
one, Your Honor.
Now, Ms. Goff, the state is offering state's exhibit number one to be used against you as evidence in this case. State's exhibit number one is the first document that I showed you on this tablet. This is the same document that have your initials on these two locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? The state is using this document as evidence in your case. All of the statements that you say you read and understood, this is being used as evidence in your case. Is it all right for the state to use this document? Okay, no objections. State's exhibit number one will be admitted. Now, Ms. Goff, is there any evidence that you are currently mentally incompetent to stand trial? Mentally incompetent, meaning that you, one, you're not aware of what's going on, you have some mental issues that affecting your ability to understand what's going on? Are there any issue? Do you have? Okay. Now, Ms. Godfrey, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily and knowingly given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And let's see, what's the agreement?
Your Honor, we'd ask the court for 12 months deferred adjudication with a fine of $500, repayment of court costs, community service of 40 hours, and requirement of the theft prevention class and the standard terms of and conditions of probation. We'd also ask that Ms. Godfrey be given credit for the 2 days in jail that she has served going towards her fine and court cost.
What's the court cost in this case? Okay. Okay, Ms. Godfrey,
Yes, sir.
the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll also be required to pay a probation fee of $60 a month, year analysis fee of $15 a month, reimbursement fee of $15. You will also be given 2 days credit towards your fine and court costs. So instead of the fine and court costs being $777, it'll be $577. Okay?
Yes, sir.
Now, your total monthly installments, that is the total amount that you'll be required to pay each month, is $136 a month. Will you be able to pay the $136 each month?
Yes, sir.
Okay. You will also be required to perform 40 hours of community service, attend and complete a theft class, and adhere to the other standard terms and conditions of this probation. Ms. Godfrey, do you understand the state's offering?
Yes,
Do you think that the state's offering in your case is fair and just?
yes.
And do you accept the state's offer? Okay, Ms. Godfrey, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Godfrey, if you successfully complete this probationary period, This case will be dismissed. It would not result in conviction on your record, and you may qualify for a non-disclosure. And you can talk to an attorney about a non-disclosure. Okay, now, Ms. Godfrey, you're gonna stand next to the bailiff, follow her direction. Once you finish following her direction, you're free to go and you have a blessed day.
Thank you. Have a blessed one, God. Thank you, sir.
Thank you. Joshua King. Okay, this is cause number 24 CCCR 1960. Case of style of state of Texas versus Joshua King. Mr. King, is that your full name? How you doing, Mr. King? That's good. Now, Mr. King, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that states you'd like to apply, that you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. King, I read your answers. Based on your answers, your case is going to be reset. Court coordinator is going to reset your case. Once she resets your case, you're free to go and you have a blessed day. Please have a seat in that first chair on the wall. Taquana Janae Williams. Oh. Ms. Williams, did I pronounce your name right?
Yes, sir.
Okay, Ms. Williams, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? So happy God. Okay, Ms. Williams, I have before me a document that is, well, first of all, Ms. Williams, how are you doing?
Good, how about yourself?
I'm doing fine, thanks for asking. Now, Ms. Williams, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
And all these initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes.
Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Williams, your case is going to be reset. Our court coordinator is going to reset your case. Once you reset your case, you're free to go and you have a blessed day. Please have a seat on the second chair on the wall.
In Tennessee, I flew out here last night to come record.
Okay,
How far out can they?
well, they're gonna give you, you're gonna get a normal reset. And the normal reset is what? How many days? 30 days?
Yeah.
But if you hire an attorney within that time frame, your attorney is going to send the court a letter of representation, and then your case is going to get reset to another court date. So in essence, if you hire an attorney before your court date, you won't have to be back. Your attorney is going to reset your case, and then it'll be further out. Okay,
Because I'm working in Tennessee right now.
I understand.
Thank you.
All right. Huh?
I'm sending back, you didn't sign.
I didn't,
Oh, you need to
oh, I got it.
sign.
Did you send it back?
Yes.
I don't see it.
Yes, I sent to.
She sent something to you. She was supposed to send it to me.
Say Shane, I know I didn't want to. Say Shane. I don't know what missed it. Say Shane, I was-
Okay, Javon Jubert. Who is that? Okay, this is cause number 24 CCCR 1642, cases filed in the state of Texas versus Javon Rashawn Jubert. Ms. Jubert, is that your full name?
Yes.
Okay, Ms. Jubert, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Jubert, you may put your hand down. How are you doing, Ms. Jubert?
I'm doing good.
That's good. Now, Ms. Jubert, I have before me a document that is titled Judge's Explanation of Rights to defendants without attorney. You recognize this document?
Yes.
And is this your signature on the line inside of defendant? And are these your initials on the line that state you would like to hire your own attorney?
Yes.
Okay, now, Ms. Jubert, before you sign this document, did you read the document?
Yes.
You understand what you read?
Yes.
Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Jubert, I read your answers. Your case is going to be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to reset your case. Once she resets your case, you're free to go and you have a blessed day. Please have a seat in that second chair on the wall.
Okay, thank you. You too.
Janisha Mims. Mims, your full name is Janisha M. Mims.
Yes, sir.
Ms. Mims, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Ms. Mims, you may put your hand out. How are you doing, Ms. Mims?
I'm doing okay. How about yourself?
I'm doing fine, thanks for asking. Ms. Mims, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line as titled defendant?
Yes, sir.
Or are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
I have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant. Signature, is this your signature?
Yes, sir.
Ms. Mims, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Mims, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you,
Yes.
and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please
Yes.
have a seat in that first chair on the wall.
I have a question. They gave me this packet. I don't know who I'm supposed to give this to.
I don't know who gave you that.
That's for her,
In
her vehicle.
Yeah.
You say, who are they? You said they gave you that packet.
Yeah, this was at performance and I didn't know if I was supposed to give this to, they put an interlock in
The
my car.
Oh, she just said show proof of interlock.
Want to make a copy and just put it in her.
Yeah,
records?
yes, you can make a copy and they'll put it in your file.
Y'all going nowhere?
But you can have a seat in that first chair on the wall. Jesse Perez. Okay, this is cause number 25 CCCR 0234. Case is style state of Texas versus Jesse Perez. Mr. Perez, is that your full name?
Yes, sir.
Perez, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Perez, you may put your hand down. How are you doing, Mr. Perez?
I'm doing great.
That's good. Mr. Perez, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line inside of defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Perez, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct
Sure.
to the best of your knowledge? Mr. Perez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of the court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will also be given information to contact him. Our court reporter will give you that information. Once she gives you that information, you're free to go, and you have a blessed day. Please have a seat in the second chair on the wall. Jonathan Marsh. Mr. Marsh, your full name is Jonathan Ray Marsh?
Yes, Your Honor.
Mr. Marsh, would you please raise your right hand? Mr. Marsh, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Marsh, you may put your hand down. How are you doing, Mr. Marsh?
Pretty all right. How about yourself, Your
I'm doing fine, thanks for asking. Mr. Marsh, I have before me 2 documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, Your Honor.
Is this your signature on the line that's titled Defendant?
Yes, Your
Or are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, Your Honor.
I also have a document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, Your Honor.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, Your Honor.
Mr. Marsh, before you signed and initialed these documents, did you read the documents?
Yes, Your
Did you
Honor.
understand what you read?
Yes, Your Honor.
Is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Marsh, I read your answers. Based on your answers, you meet the eligibility requirements of the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Reuben Cartwright. Attorney Cartwright will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Thanks, Your Honor.
Please have a seat in that third chair on the wall. Ashley Renee Lang. Mr. Lang, Ms. Lang, would you please stand right here? Now, Ms. Lang, your full name is Ashley Renee Lang.
Get my middle name, yes, Ashley.
Okay.
Bailey.
Ms. Lang, do you have any gum in your mouth? You gotta take it out. There's a trash can right in front of you.
I didn't
To your
mean
right.
disrespectful.
Okay. Okay, now, Ms. Lang, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Ms. Lang, you may put your hand down. How are you doing, Ms. Lang?
I'm trying. And
Okay,
you?
I'm doing fine, thanks for asking. Ms. Lang, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir,
Is this your signature on the line that's titled Defendant?
it is.
And are these your initials on the line that state you like to apply for court-appointed attorney?
They are.
I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this
I
document?
do.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Lang, before you signed and initialed these documents that I just showed you,
Yes, sir.
did you read the documents?
Yes, sir.
Did you understand what you read?
To the best of my-
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Lang, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you, in this case, is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go, You have a blessed day. Please have a seat in that first chair on the wall.
You have a blessed day as well, Judge.
All right, thank you.
Thank you.
Tanya Skidmore. Ms. Skidmore, your full name is Tanya Yvonne Skidmore.
Yes.
Ms. Skidmore, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Skidmore, you may put your hand down. How are you doing, Ms. Skidmore?
Been better.
Doing better? You been better? Okay. Sure you've been worse too.
I'm more blessed than I deserve, so I dare not complain.
That's good. I know what you mean. Now, Ms. Skidmore, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Engineer. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Skidmore, before you sign the initial of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Absolutely.
Okay, Ms. Skidmore, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that is appointed to represent you is Attorney Christy Cawthon. Ms. Cawthon will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that second chair on the wall. Herbert Smith. Miss, okay. This is cause number 25 CCCR 0236. Case is style of state of Texas versus Herbert August Smith. Mr. Smith, is that your full name? Mr. Smith, could you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Smith, you may put your hand down. How are you doing, Mr. Smith?
I'm doing okay, so.
I'm doing fine, thanks for asking. Now, Mr. Smith, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendant Without Attorney. You recognize this document?
Yes, sir.
And is this your signature
Yes,
on the
sir.
line that's titled Defendant?
Yes, sir.
Or are these your initials on a line that states you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And is this your signature on the line that's titled Defendant Signature?
Yes, sir.
Now, Mr. Smith, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, Mr. Now, Mr. Smith, I was going over these documents. And um, based on the information that you provided, you do not meet the eligibility requirements for the appointment of a court-appointed attorney. Okay? So at this point, you can you still have two options. You can either ask that your case be reset to hire your own attorney, or you can waive your right to an attorney and represent yourself. Okay?
All right.
And so what I'm going to do, I'm going to have the bailiff to hand you the judge's explanation of rights to defendants back. And you can make your choice.
Can I ask why I'm not eligible?
Hmm?
Why I'm not eligible?
Because you don't meet there, I'm looking, you got your income that you have.
4,000.
Yeah, you got 36, but when I take your expenses from your income, you still have money left to hire an attorney. Okay, and you still have some disposable income.
But I don't think I wrote everything down because I didn't know we were supposed to put the car insurance and all that. So some stuff is not on.
Well, I mean, I'm only,
It's all right.
I don't know that. I mean, if you need to make an adjustment to the form, you can. Just happen to have a seat at that table right there. Now, when you're talking about transportation, that not only includes fuel, oil, maintenance, but it also includes insurance that you may have to pay, as well as a car note if you're paying a car note. Okay. Okay, you can take a seat right there at that table. Yeah. Okay, this is cause number 25CCCR 0204. Case is style of state of Texas versus. Is that Kanisha Naomi Tyson?
Naomi.
Naomi Tyson? Okay,
No, no worries.
okay, I'm just saying, I'm going by what they have on the paperwork.
Okay.
Now, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing?
Good, how are you?
I'm doing fine, thanks for asking. Now, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Mm-hmm.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for the appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Images. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, before you sign and initial these documents that I just showed you, did you read the documents?
I did.
And did you understand what you read?
I did.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Mm-hmm.
Okay, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go on your best day. Please have a seat in that first chair on the wall. Austin LaFleur. Okay, Mr. LaFleur, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. LaFleur, you may put your hand down. How are you doing, Mr. LaFleur?
Fairly well. How about you, sir?
I'm doing fine. Thanks for asking.
Mutuality.
Now, Mr. LaFleur, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that's titled Jefferson County Affidavit of Images. You recognize this document?
Yes, I do, sir.
And on page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is that your signature?
Defendant, meaning,
Is this your signature?
Yeah.
That's your signature? Okay. Now, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. LaFleur, I read your answer. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Faggart. Attorney Faggart will be given information to contact you. You will also be given information to contact him. Our court reporter will give you that information. Once she gives you that information, you're free to go and you have a blessed day. Please have a seat in that second chair on the wall. Miracle Ford. Ms. Ford, would you please raise your right hand? Ms. Ford, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Ford, you may put your hand down. How are you doing, Ms. Ford?
Good.
I'm doing fine, thanks for asking. Ms. Ford, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? On page 2 of this, well, on the next document is titled, well, first of all, is this your signature on the line that's titled Defendant? And are these your initials on the line that states you'd like to apply for a court-appointed attorney? Now, the next document, Jefferson County Affidavit of Images, you recognize this document. On page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Ms. Ford, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct
Yes.
to the best of your knowledge? Ms. Ford, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Okay, Herbert Smith. Okay, now, Mr. Smith, please raise your right hand. You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Ms. Smith, you may put your hand down. And Mr. Smith, I have before me, you have to kind of affidavit images. Do you recognize this document? And on page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, Your Honor.
Now, I'm gonna go back to this document. Judge's explanation of rights to defendants without attorney. Miss, you hand this back to her? Does he got he got initials in 2 locations. He's asking for a court appointed attorney.
Good.
No, he marked it off.
No, he's asking for a court appointed attorney. He adjusted his,
Oh, okay. So mark that.
oh, you got whited out.
Yeah.
That's some white out right there.
Yeah, you can mark it up. I wanna be the same. That's cool. And just put your initials. Oh, that's good.
That's me.
Okay. Now, Mr. Smith, this document that's titled Judge's explanation of rights to defense without attorney, recognize this document?
Yes,
And is this your signature on the line inside the defendant?
yes, Your Honor.
And are these your initials on the line that state you'd like to apply for court appointed attorney?
Yes,
Now, before you sign both of these documents, did you read the documents?
yes, Your Honor.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, Your Honor.
to the best of your knowledge?
Yes, Your Honor. Now, I do have a question. If I do decide to hire a lawyer, can I still do that too?
Yeah. Yeah, you could always,
I mean, it's hard right now because I'm paying for a room.
okay, that's, let's see.
Yeah.
Okay, now, Mr. Smith, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of court appointed attorney. The attorney that will be appointed to represent you, in this case, Attorney Todd LeBlanc. Attorney LeBlanc will give information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you're free to go. You have a blessed day. Please have a seat in that second chair on the wall.
Thank you.
Oh, okay.
I'm so sorry, I'm down.
That's okay.
337 651 8 9 7 8.
I don't know, I have this info as well.
No different.
Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket on today's date, March 18th, 2025. Next case is call number 25 CCCR 0212. Case is style of state of Texas versus Salvador Version. Salvador Version was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Salvador Version at the courthouse door. Salvador Version did not answer. Salvador Version has not appeared in court since the court has been in session. The time now is 11:54 a.m. on today's date of March 18th, 2025. Ms. Bailey, could you please call the name of Salvador Version at the courthouse door?
Yes. Salvador Virgin. Salvador Virgin. No response, Your Honor.
Okay, Salvador Version name was just called again at the courthouse door. Salvador Version did not answer. A reasonable time has passed to give Mr. Version an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
The state will move for a bond forfeiture, Your Honor.
That motion will be granted. Salvador Version bond will be forfeited, and a warrant will be issued for his arrest and cause number 25 CCCR 0212. Next case is cause number 25 CCCR 0222. Case is style of state of Texas versus Jeanette Johnson. Jeanette Johnson was scheduled to be in court this morning at 9 a.m. for the court's arraignment. Jeanette Johnson name was called at about 9 a.m. at the courthouse door by the court's bailiff. Jeanette Johnson did not answer. Jeanette Johnson has not appeared in court since the court has been in session. The time now is 11:55 a.m. on today's date of March 18th, 2025. Ms. Bailiff, would you please call the name of Jeanette Johnson at the courthouse door?
No response, Your Honor.
Okay, Jeanette Johnson name was just called again at the courthouse door. Jeanette Johnson did not answer. A reasonable time has passed to give Ms. Johnson an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Yes, Your Honor, state will move for a bond forfeiture.
That motion will be granted. Jeanette Johnson's bond will be forfeited in cause number 25 CCCR 0222. And this will conclude the calling of the arraignment docket on today's date, March 18th, 2025, in County Court at Law number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. The court will be in recess till 1:30 for the court's trial. Prosecutors, you are excused.